Hello, everyone. My name's Tim, and I'm going to take you down a rabbit hole and get you lost in the law. I'm a second year Canadian law student, and today we are going to be looking at involuntary confessions using a framework developed by the Supreme Court case Oickle. We're in for a good one today, and then after we have a look at some of the general provisions, I will pose a hypothetical scenario, and you be the judge. Would you allow that confession, given what you're about to learn here? I'm curious to see what people think. I don't think it has a clear and I don't think it has a clear answer. I really don't. I do believe that this would test the bounds of the framework established here. I do think that it's relevant in the realm of the emerging technology when it intersects with the law. So let's have a look first at the case. We'll learn about it, and then I'll pose the hypothetical at the end. Or you can just skip to that part. Who am I to stop you? All right, let's get into it. So the case of Oickle is an accused who is arrested on suspicion of arson. And he provides a confession. However, the circumstances that confession was taken give rise to a legal challenge. And we'll go into why in just a second. You're very familiar with the, you should be familiar with the idea that forced confessions through torture or through chemical inducement, they tend to be very unreliable. And the reliability of confessions will be central to this discussion. So without further ado, let's get into the case. Let's have a look here. So during the police investigation of a series of fires, the accused agreed to submit to a polygraph. Now, polygraphs are inadmissible in court. That does not stop police from using them as an investigative tool. That is addressed further down here. It's not going to make up any part of a greater rule. The court has just said that we shouldn't interfere with the police's ability to investigate crimes, so long as they're not crossing certain boundaries. And so they've ruled that using polygraph as an investigative tool is absolutely allowed. You cannot put that evidence in front of the jury that the accused has failed a polygraph test, because it's not admissible in court. The statements that the accused make, however, are admissible, whether or not they were during, before, or after the polygraph. Anything the accused, remember, when they tell you anything can be used against you in a court of law, they actually mean it. So let's have a look at what else happened here. The test took place in a motel, and the police audio taped the events. The accused was informed of his rights to silence, to counsel, and to leave at any time. These are important. They are relevant, and they do make up part of the analysis as to whether the confession was voluntary. He was also informed that while the interpretation of the polygraph tests were not admissible, anything he said was admissible. The test concluded around 5 p.m. The officer conducting the test informed the accused that he had failed it. The accused was reminded of his rights and questioned for 1 hour. At 6:30 p.m., a second officer questioned the accused, and after 30 to 40 minutes, the accused confessed to one of the fires and provided police with a statement. He appeared emotionally distraught at this time. I want you to keep in mind the timeline here, too. The timeline is important. At the police station, he was arrested and warned of his rights, once again, the secondary police warning. At the police station, he was placed in an interview room equipped with videotaping facilities where he was questioned about the other fires. Around 8:30 p.m. and 9:15 p.m., so in between those two times, the accused indicated that he was tired and wanted to go home. He was told that he had been arrested and he could call his lawyer, but he was not allowed to go home. A third officer took over the interrogation at 9:52 p.m. So at this point now, if you consider the interaction before the test, further in the case, they said the polygraph was scheduled for 3 p.m. So go from 3 until almost 10 o'clock. He's been with the police for 7 hours now. He questioned the accused until 11 p.m., so now 8 hours, at which time the accused confessed to setting 7 of the 8 fires. The police took a written statement. He was placed in the cell to sleep at 2:45 a.m. So all this process is gone, and we are now, we've come close to 12 hours of the police interaction before he's finally put in his cell to sleep. At 6 a.m., the officer notices that he's awake and asks whether he'll agree to a reenactment. The accused then takes the police and reenacts the fires. There was a voir dire held at court as to whether that statement was admissible. The trial judge ruled it was admissible. The Court of Appeal ruled it was not admissible. It was an involuntary confession and entered an acquittal. The Supreme Court is now being asked to adjudicate on this. They rule that the appeal should be allowed, the conviction restored, the statements are admissible. They're going to go into a discussion of what underpins the idea of voluntary confessions and why an involuntary confession would be inadmissible. The confessions rule focuses not just on reliability, but also voluntariness. The common law confessions rule, again, so the common law originates from prior case law, right? Jurisprudence. So there is a common law confessions rule, but there's also a confessions rule in the context of the Canadian Charter of Rights and Freedoms. And in fact, the interplay between the two here are discussed in this Supreme Court case, right? The common law confessions rule offer protections beyond those guaranteed by the Charter of Rights and Freedoms. The Charter of Rights and Freedoms are actually very basic when it comes to confessions. Anything you say to the police is usable. You have the right to be free from arbitrary detention. You have the right to be free from torture. Cruel and unusual punishment. You have the freedom that evidence taken, evidence obtained in violation of your rights should be excluded, unless there's some other admitting criteria, such as the reasonable limit guaranteed in Section 1 of the Charter, or whether excluding the evidence would cause the justice system to for people to lose faith in the justice system. So, and that covers those. Again, the video isn't going to be talking about this particular idea, but just for greater context, that charter right just guarantees those fringe cases where the police technically violated your charter rights, but the violation was considered light in the amount of the overwhelming evidence. That doesn't mean you're entitled to the acquittal. And you may seek other compensation for the violation of your rights. But the charter leaves that as an option to the courts, saying that yes, technically a violation occurred. That violation does not rise to the to the level of egregiousness that requires us to set you free and loose in society. A very rarely used portion of the charter, let me tell you, because oftentimes, yes, the violation of someone's charter rights, the typical remedy is you exclude the evidence. If that evidence that is excluded causes the Crown to not pursue any charges, there's no evidence that they could use to convict you, then yeah, you go free, and that's the most common way that happens. So that was a quick sidebar regarding just how the charter rights can sometimes be quite flexible depending on the situation. That was always their intention. The common law confessions rule can kind of offer a bit more protection. The right to silence is actually drawn from common law more so than the protection granted by the charter. Maybe I'll get into a case that covers that, but I think the case authority on that one would be Hebert, or Hebert. if you want to do the English pronunciation. That one would be that would be the leading case authority, I believe, on the common law right to silence. So this is the common law confession rule. And while it may be appropriate in certain cases to interpret one in light of the other, it'd be a mistake to assume one subsumes the other entirely. They work together. They're not one saying that the other doesn't exist. In defining the confessions rule, it is important to keep in mind its twin goals of protecting the rights of the accused without unduly limiting society's need to investigate and solve crimes. And that's the justification they use to rule that police can use polygraph evidence against you when they're doing the investigation. And if that evidence causes you to confess, they then take the confession to court and use that to convict you. They can't use the polygraph in court. They can use it to secure the confession. And that is taken, that's noted here in the idea that police do need tools to be able to do their jobs, and it's not the court's place to take those tools away just because there has to be a good reason. There has to be a good reason to take those tools away. It's not the court's place to police the police in a respect. At least when it comes to the methods they use to investigate crimes. That's not the court's expertise. It's not really their they're not best equipped to make those judgments of what is effective crime solving. They will and do step in when that conduct violates your rights. That's what they're there for. The application of the confessions rule is of necessity contextual. So you're not going to find these hard and fast rules that because they simply cannot account for the variety of circumstances that could arise in a confession. When reviewing a confession, a trial judge should consider all relevant factors. The judge should strive to understand the factors or the circumstances surrounding the confession and ask if it gives rise to a reasonable doubt as to the confession's voluntariness. So we have the reasonable doubt standard here. And so if defense puts this into issue, it is incumbent on the Crown to prove beyond a reasonable doubt that the confession was voluntary. If the judge has any, and this is done at the judicial level, right? So this is done at a voir dire hearing or a show cause hearing. I think that's what the French translation is. I don't actually speak French. I forget what voir dire. I think it's show cause. Anyways, no. Dire means to talk, I think. And voir means see. To see. It's a toxie. Okay. Anyways, French. Oh, my webcam froze. 1 second. Okay, we're back. Sorry about that. I don't know what happened there. Man, technical issues are really getting the better of me today. Where was I? I'm not sure exactly where I left off. Right here. There's a multitude of factors when considering relevant. Oh yeah, I was spitballing about voir dire. Good. Anyways, sidebar aside. The judge should strive to understand the circumstances surrounding the confession and ask if it gives rise to reasonable doubt as to the confession's voluntariness, taking into account all aspects of the rule. And so, yes, the relevant factors include threats or promises, oppression, the operating mind requirement, and police trickery. While obviously imminent threats of torture will render a confession inadmissible, most cases will not be so clear. The use of veiled threats, for instance, require close examination. That one's pretty clear. The police may often offer some kind of inducement to the suspect to obtain a confession. This becomes improper when the inducements, whether standing alone or in combination with other factors, are strong enough to raise a reasonable doubt about the voluntariness of the confession. An important consideration in all cases is to look for a quid pro quo offer, right? So some material benefit that you'll get by giving the confession, to the point where the perpetrator is weighing the benefits of the false confession versus the circumstances they presently see themselves in. Um, when you're in that realm, that that makes that confession unreliable. So, um, that's pretty simple, pretty simple to explain, and regardless of whether that comes in the form of a threat or a promise, oppressive conditions and circumstances clearly also have the potential to produce an involuntary confession. In assessing oppression, courts should consider whether a suspect was deprived of food, clothing, water, sleep, or medical attention, was denied access to counsel, was confronted with fabricated evidence, or was questioned aggressively for a prolonged period of time. Now, this is something the court looks to or considers. Especially with the view of fabricated evidence, this does not mean the police cannot use that. In fact, they do use fabricated evidence to try and induce a confession. Um, the thing that the court cautioned on with fabricated evidence is where it has, especially where the suspect's memory, their own memory, is foggy, and they have a hard time remembering what happened, and the police fabricate evidence to the point where the suspect believes something other than what actually happened occurred. For example, if the suspect is given fabricated evidence and then they give their confession and incorporate the fabricated evidence into that confession, that's not a reliable confession. Um, they could say the police could say, for example, we caught you on video, or we have 6 witnesses that said you did this thing, and the person says, yeah, I remember seeing the 6 people there, and there were not 6 people there. So of course that confession is unreliable. So the fabricated evidence is meant to caution against taking advantage of someone's inability to remember something and implanting the false memories. So that's what the court really wanted to caution on when they referred to fabricated evidence. That is certainly not to say that the police cannot use fabricated evidence. They most certainly do. And we'll get and then there's other police trickery they use too. Mr. Big operations, which I'm told are the concept originated in Canada, and I think we exported that to other jurisdictions. I'm not sure if police in other jurisdictions use it or another or some twist on the concept. But yeah, Mr. Big operations would be, well, an entire undercover sting operation designed to get someone to confess to something. So that is R versus Hart would be that decision. Um, that is that would cover the admissibility of a Mr. Big confession. I'm not going to cover that today. It's certainly worthy of its own video and taking a bit more care and time to go through it. But it's certainly related to this idea. You should also take into consideration if the suspect was questioned aggressively for a prolonged period of time. The operating mind doctrine only requires that the accused knows what he is saying and that it may be used to his detriment. So things that impair your mind, remember, voluntariness is always something that you choose to do, right? Something then where you have weighed, the decision has had meaningful impact inside your mind, and you have then made that decision to do so. So drugs which impair that, right, mind altering drugs would run afoul of the operating mind doctrine, especially hallucinogens, where you give a confession that has no basis in reality. It's obviously unreliable. This is the rule that covers that. The accused has to know that you know, the words he is speaking are of consequence. If he doesn't know that, then his mind is not in a realm that lets you ascertain the reliability of such a confession. Like oppression, the operating mind doctrine should not be understood as a discrete inquiry, completely divorced from the rest of the confessions rule. Right, so everything's taken into consideration, especially when they go back to the oppressive police conduct. If that psychologically breaks the person and they have a psychotic breakdown, that confession is not going to be reliable. They have entered a state of mind that is divorced from reality. Lastly, and this is where we get to the meat of the video, the police use of trickery to obtain a confession must also be considered in determining whether a confession is voluntary or not. Police trickery. This doctrine is a distinct inquiry. While it is still related to voluntariness, its more specific objective is maintaining the integrity of the criminal justice system. There may be situations in which police trickery, through neither violating the right to silence nor undermining voluntariness per se, is so appalling as to shock the community. In such cases, the confessions should be excluded. The Supreme Court gave a couple of examples. I can scroll down to them here, but their examples, the two examples they gave that I want to latch onto, is police impersonating a chaplain or a legal aid lawyer. The chaplain would be the faith leader at a prison. And of course, the sanctity of religious confessions is well known and understood. Religious leaders make the decision to break that sometimes. It's certainly been, it's happened where someone will go to confession and confess they committed a crime, and the priest will go to the police. That is between the priest and God, right? Violating that sanctity has nothing to do with the police. That is the priest is making that decision. The police then just take the information and use that to conduct their investigation. So that's between the faith leader and God, violating that sanctity of confession. The legal aid lawyer is much easier to explain because of solicitor-client privilege. A suspect may say things to their lawyer they would not say to the police, believing that what they say to their lawyer is protected under privilege. So a police impersonating a lawyer in order to exploit that relationship would shock the community. I think that is without question. The last example the Supreme Court gave was the injection of truth serum under the disguise of insulin to a diabetic accused. And I just thought that one was an odd one for the judge to come up with. First of all, I I would be I would be shocked if that happened at any time in history. Um, by the way, shout out to Canada for giving the world injectable insulin to treat diabetic patients. That was Dr. Frederick Banting, and his oh, I forget the other. Dang it, I always forget the other doctor. There was two doctors that well, actually it was a whole team, but like two doctors who shared the Nobel Prize for inventing insulin. Or they didn't invent it, but they isolated it and invented the treatment of intravenous or injection of insulin to treat diabetes patients. So shout out to Canada for that one. Um, but again, it was an odd example that the Supreme Court came up with because I mean, if I don't think such a thing has ever happened. At least in the context of police, maybe the CIA has done that. I don't know, but I can't imagine the police would do such a thing. Uh, anyways, so what I'm saying is that example doesn't really help establish the boundary of that test very well. Um, So we get the idea that there are positions of privilege that the police can impersonate that would rise to the level of police trickery that shocks the community. Again, that's the test. It has to. It's not enough that you find it just in poor taste or distasteful. Um, it has to be something that the society as a whole would have a problem allowing to continue. That they would be rightly concerned, a reasonable person, properly informed of their charter rights, um, would have, would have concerns about police using this on guilty people. So, and again, that level of trickery doesn't speak to the voluntariness per se. The person could, but it's the extreme manipulation of the situation that causes people to lose faith in the justice system. And so again, it is we're importing the language used in the charter when it comes to, but it's to the benefit of the accused in this case, right? Something that shocks, something that is shocking or appalling to the community would cause it to question the integrity of the justice system. And so such conduct should be discouraged. The way you discourage that conduct is by ruling that any evidence obtained from that conduct is inadmissible. And so that's how you get there. So I want to end off with my hypothetical scenario that came up in discussion. And I'm not so sure this has an obvious answer. I think it's going to depend on which judge you get. Or maybe it does. Who knows? But let me know in the comments what you think. So, what if, and we've seen that, like, impersonating, the impersonation test, it's not just impersonating someone that you would trust. So, it's not enough that you impersonate, I don't know, a well-respected elder in the community, right? It's not enough that you just impersonate someone like that in order to get the confession. It has to be someone that most people would understand that there is a unique relationship there that the police are exploiting for purposes of getting this confession. So the hypothetical I wanted to put together, and this is only hearsay, I've only heard this used, I've never seen it come up in a court case before, but I heard one time uh, from another lawyer that the police will sometimes call relatives on like a tablet or like an iPad or something and show it to the accused, and where they can pressure the accused into tell the police what happened, tell the truth, whatever. And that alone would not rise to any of these exclusionary rules. But I wonder if the police, under police trickery, if they used a deep fake of your mother, for example, and they show it on the iPad and they present in such a way to make you believe that you're talking to your mother, like, live. And your mother says, like, tell the police what happened, just tell the truth, we'll help you, we'll get you through this. Just tell the police what happened. Um would that impersonation, would that trickery shock the community? Would that cause you to question the reliability of that confession? I think if your mother's pressuring you, it's not unreasonable to think that someone would admit to something they didn't do in light of, the pressure from your mother. I think certainly relevant here is the type of relationship you have with your family. This wouldn't work, this argument wouldn't work if you never talked to your mother, right? But if you're someone who has a very close relationship to your mother, or your father or another family member, right? If they raised you from birth or something, like they're your guardian, maybe a foster parent, something that rises to that level of privileged information, right? The thing that you would tell your mom that you would never tell the police. Now, there is no legal protection on that, right? Something you tell your mother, if your mother goes to the police and talks to the police, she's, that's admissible. So, again, we're getting into this, does it quite fit this test? I'm not entirely sure. For the purposes of this hypothetical, let's assume that the accused believes that they are indeed talking to a live, their live family member. That belief is reasonable, objectively reasonable, and that the police had done so with the purpose of eliciting that confession out of the accused. So the accused confesses, the police charge, and you go to trial. And the defense lawyer says, "Man, that is some deep level emotional manipulation. I want to exclude the confession as evidence." So let me know in the comments. Let me know what you think. Um, It'd be interesting to hear some different perspectives on that one. If you're new to this channel, if you're new here, in addition to legal topics, I also sometimes go into political topics. I think the intersection between law and politics is very interesting. I think that these two fields are tightly intertwined with one another. I find that things that lack judicial solutions often have political solutions. This might be one of them. I think that perhaps Parliament may legislate where the court has not, ruled or closed this route entirely. And so, if the will of Parliament should be respected in that case, and the court typically defers to Parliament as long as they're operating within the bounds of the Canadian Constitution. Um, Secondary to this hypothetical is, if you believe that this is something that may happen in the future, should Parliament pass a law that protects and guards against this type of trickery, this type of emotional manipulation? Um, or do you think that, well, even under the pressure of your mother, if you give a confession, it's voluntary, it will be it's still reliable? I think the central question is: has anyone ever told a lie to their mother, or sorry, has anyone ever confessed to something they didn't do to their mother under pressure to do so, in order to just take the punishment and say, well, if I confess to my mother, then, well, for whatever reasons, and I'm going to get into the whole why, because it's going to be individualized to each person. But let me know. I'm interested to hear. In the meantime, this is my law tube channel, Lost in Law. You can help me out a lot by sharing my videos. I'm trying to build this channel up. The better this channel does, the more time I can put into it. Something I'd love to do is be able to report on Canadian cases. We don't have TV cameras in Canadian courtrooms. We have cameras at our Court of Appeal, so I could cover those, but I don't know. I don't think they're live. I'm not sure if they're ever live. I think the media is there, but I think they don't broadcast them live on like a live stream. So, but I do think it's important that Canadian courts and court cases get reported on, and it's something I would like to explore doing. If my channel, blows up, if it becomes big, it gives me the resources and the audience to do so, who will benefit from this. If you are watching this content and you're wondering how to support me, I can't take super chats at this time. I think I'm 170 people away from being able to accept super chats, subscribers, from being able to accept super chats, and another 500 extra people on top of that for advertisement monetization. In the meantime, on my own website, lawstinlaw.ca, you can find a donation form there to be processed by my third-party payment processor. So I don't store any of your financial information on my website. If you want to leave me a message, you can. You can also make an anonymous donation. That is perfectly fine. Any little amount counts. Again, it helps me. Hey, I can upgrade my equipment, get a better camera, or maybe a worse camera. Depends on your perspective. So consider. And if you can't do that, I would certainly appreciate a like and a share. Get me in front of the new audience members and see if this is the kind of stuff they like. Check out my other videos, especially if you want to see political analysis. I've done a couple on this channel. It's a slow time for election season right now. Let me know in the comments too if you're interested. I've been thinking about covering the going back to the recording of the Republican national debate. The Republican primary debate. And covering it the same way I covered the Manitoba debate. If that's something you'd like to see, as I break down and analyze that, we'll do it. The Art of Catching Liars Part 3. I do suggest you check out the videos, The Art of Catching Liars Part 1 and The Art of Catching Liars Part 2. Part 1 was looking at the cross-examination in the Amber Heard trial that made, Camille Vasquez very famous. Sorry, not just Camille Vasquez. She's the only one I remember, but made the Johnny Depp legal team famous. The takedown of that doctor. The Art of Catching Liars Part 2 was my analysis of a provincial general election leaders debate. Now, it was Manitoba. It wasn't a big province in this country. But, it's a debate equivalent to governors in the states, and so I think it's interesting to look at. If you want to, I don't know, if you want more legal content, again, I'm not a lawyer. I can't give legal advice. I'm a law student. So when I look at these, when I look at cases, when I make these analyses, I do so from the academic theory standpoint, because I don't have experience to draw upon. But if this is the kind of content you love watching, then let me know. So, with that, have a great day, everyone. Great evening, great morning, whenever time you're catching this. And we'll see you around. Stay frosty.